edge case, meaning it could fall on either side, you're not sure?
I am sure, and that the message isn't in the product. It's not in the photograph. But even if this court were to find that it was, the court would still have to protect the speech. And the court could draw a line in a different place, as it has juxtaposed Loving and Obergefell in terms of the beliefs between same-sex marriage.
So just,
sorry. In Obergefell, did the court say that religious objections to same-sex marriage are the same thing as religious or other objections to people of color?
No, in fact, it said that decent and honorable people hold beliefs about marriage, believing that there's a gender-differentiated marriage and that that's based on reasonable religious and philosophical premises. When we review Loving, there's a very different...
But tell me how to write this decision for you that draws the line just on gay marriage, because that's what you seem to be saying right now, but draws a line that doesn't affect my example of a disabled person or an interracial couple. You're saying it's just because it's compelled speech.
I'm saying that the interracial couple, the disabled person, the lesbian graphic designer, the Democrat, the Republican, no one should be compelled to speak a message. And this court has never found a compelling interest that's narrowly tailored.
So you're saying a print shop, a web designer, a cake maker, a photographer, a jewelry maker, they can refuse to serve anyone they want to refuse because they have a deeply felt belief that taking pictures of black couples, black and white couples, taking pictures of disabled people, people are going to believe that they're speaking that message.
I'm not saying that at all. What I'm saying is that in every free speech case, the court looks first, is there speech? In many of the situations you raised, there would not be speech.
But why not? I'm saying your identical website, and I don't see a page in here where it says, I am speaking 303. That's on your personal website. It's not on the wedding website. I've asked you to show me where, in which pages, it's your message as opposed to the couple's message.
Every page is my client's message. Just as in a newspaper that hosts an op-ed written by someone else.
Does it,
or Hurley, the parade.
But then why does an off-the-shelf website, the creator of an off-the-shelf website, is then speaking? That's what you're saying.
No, because the compelled speech doctrine doesn't apply once you've entered that speech into the stream of commerce. When the speech is completed, the compelled speech doctrine no longer applies. But in addition, there are 20 states that have filed an amicus brief in this case and said they're right now using their public accommodation laws to allow message-based protections as Hurley would require, and they're not experiencing these issues.
But you're not asking for that. You're saying, I don't want to serve a particular person, a disabled person, a black and white couple, a disabled couple, a gay couple. You're basing it not on the nature of the message, you're basing it on who you're serving.
I don't think that's a fair characterization. The stipulated facts in this case are that Ms. Smith has LGBT clients. She serves them regularly. She has all kinds of clients.
Tell me how that's different, by the way. What you're basically saying is in our Oleg barbecue case, the company there said, I'll serve blacks, but only on a takeout window, not inside my restaurant, because that sends a message that I endorse integration.
Ms. Smith isn't looking to send a message through her conduct.
What you're saying is, I want to give gay couples a limited menu, not a full menu, just the way that luncheonette said.
No, just as this court found in Hurley, she's being asked to shape her speech by a third party. And it's about what messages she is creating. In Ollie's barbecue, they weren't engaging.
When I sit down to eat a meal by a full chef who creates this beautiful picture on a plate, why can't he say, I make specialized meals for my clients. I will not serve a black person I won't serve a disabled person because they can't appreciate fully what I'm creating. That's basically what you're saying.
No, I don't think it is what I'm saying. We're conflating service and speech in that instance. A chef
But
isn't.
why is yours not a service?
May I answer the question?
Yes.
Because it is creating speech. And the public accommodation law is broad enough to ensure that we're not crushing consciences, not just of Ms. Smith, but of her LGBT friends.